Hello, and a very warm welcome to everyone attending today. My name is Philip Hoddell, and I'm the chairman here at Burkitt Long. I'm delighted to be able to introduce this Wednesday webinar. As you may know, Burkitt Long are offering regular webinars on a wide range of legal topics. Future subjects will include a session on statutory wills, what they are and when you need them, and also some guidance on the duties and responsibilities of trustees. If you're interested in any of our webinars, please sign up at www.burkittlong.co.uk/events. Today, we're delivering a construction law update. It will be presented by Suryen Nullatamby, a senior associate and team leader in the Burkitt Long dispute resolution team. Suryen recently won a national award for his work in the construction field, and at Burkitt Long we are both delighted for him and very proud of his achievement. He will be taking questions at the end of what promises to be a fascinating talk. So without further ado, I will hand over to Suryen, your host for today.
Thank you for this introduction, Philip. Hello, everyone. Welcome to this Wednesday's webinar. My name is Suryen Nullatamby. I'm a senior associate solicitor and a team leader in the dispute resolution team at Burkitt Long. I'm a dual qualified lawyer, being a barrister and a solicitor advocate. I specialize in construction disputes and construction adjudications. Most of my work are around payment disputes, delay and disruption claims, defective designs, workmanship issues, professional negligence claims, and also issues to do with this very topic today, which is termination of construction contracts. I'm also an accredited adjudicator. I serve on various UK panels, that's the CIOB, the CIC, the UK Adjudicators, and the RICS. I will take questions at the end, so please do make use of the Q&A facility on your screen. The topic of this webinar is about termination of construction contracts. A contract can be terminated by agreement of the parties to the contract, by mutual agreement, or after a contract has been duly performed. However, in other circumstances, very often it is difficult and complex to decide when, how, and on what grounds to terminate a contract. So I'm going to run through what I'm going to be talking about today. I'm going to give you an overview of the right to terminate, both at common law and under the contract, and how it is done. I will also talk about the consequences of termination and provide you with some practical steps when deciding whether to terminate and how to terminate. I shall also give you an overview of the risk and effects of termination and what other opportunities may arise from termination. The information in this presentation is for general purposes only and does not constitute legal advice. This information is correct as at 2nd of November 2022 and is subject to legislative changes. So the first question is, what is termination? Contract termination excuses all parties from further performance of their primary obligations to pay and perform from the termination date. The termination begins and ends to the party's primary obligation, like I say, to perform the primary objectives or primary subject matter of the contract and any payment obligations in the contract. However, the contract does still exist and other duties under the contract survives. These duties include secondary obligations, provisions that are procedural or ancillary to the subject matter of the contract, accrued rights, meaning rights that have been accrued by the time of termination. For example, if there were issues with the construction works, such as defects, these rights will survive. If there were payments that were due during the works and been certified, these rights will subsist. And there are other provisions that are intended to survive. For example, a provision in the contract which prohibits an action for, say, 6 months after termination. So when do we terminate? There are various grounds which we can rely upon in order to terminate a contract. But broadly speaking, I will talk about 4 of these grounds. The first one being breach of contract by another party. And that could arise if, for example, that party refuses to perform the contract, or the performance is unsatisfactory, or in another case, they might be performing their main obligation acceptably, but have breached another term, such as a confidentiality provision in the contract. Another ground for terminating a construction contract, could be the contract is no longer profitable. For example, the cost of performance has become prohibitive, or the customer can get the same goods and services cheaper elsewhere, or the client no longer needs the goods and services. And the fourth one being insolvency, meaning the other party has gone into insolvency proceedings or is about to do so. So how do we terminate a construction contract? Very often, a party's right to terminate is not clear-cut and may be disputed. If you wish to terminate, you should take great care, as there may be drastic consequences following a wrongful or unlawful termination. I have seen this on many occasions during my career, in my practice, where an employer or a contractor may have terminated the contract wrongly, and the consequences, whether it's financial, have been quite heavy upon them. Therefore, at the outset, my advice is you should identify all possible termination rights, which include the common law right to accept a repudiation. Even if it's not mentioned in the contract, this right is available unless clearly excluded by the contract. So you have common law right or contractual right to terminate. There are also contractual rights to terminate for cause or convenience, meaning you can terminate the contract if the contract provides that you can terminate for no reason, for no default. So what are the legal grounds for termination? First, I will deal with common law. The contract can be terminated at common law by reason of repudiatory breach. This usually happens when a party has committed or is likely to commit a fundamental breach or more serious breaches of a contract, which is significant, and that indicate that the party to the contract does not intend to be bound by its contractual obligations. The other party, the innocent party, may either elect to carry on with the contract and claim damages for the breach, or in the alternative, it can elect to accept the repudiation and claim for damages. It is important, however, to make sure that you get the termination right. Otherwise, the party may claim that you have repudiated the contract yourself by the wrongful termination. In order to decide whether a breach of contract amounts to repudiation or repudiatory breach, you need to identify whether there's been a serious breach, which I would say goes to the core of the contract. For example, if a contract provision makes time of the essence for the performing of an obligation or a duty by a clear deadline, or within a particular timescale, then even a small delay would give an innocent party the right to terminate. Another example is where one party, whether by words or conduct, refuses to perform the contract in some material respect, or shows an intention not to perform the contract at all, and such as failure to attend site to commence work, or abandoning the site during the works. So what are the implications of termination? Usually the innocent party would send a notice to the other party who is at default, and that notice would take effect immediately. However, again, under the common law, termination is without risk, is not without risk. You need to assess the practical implication, for example, the timing, which is key. You should make sure that you're not acting or conducting in such a way so as to affirm the contract. Otherwise, you would have lost that common law right to terminate. You need to consider what happens with materials on site and with the site itself. What duties would arise following termination, particularly what must the parties do in respect of confidential information or personal data or other documents. What other contractual duties and accrued rights survives termination, and whether it would be more profitable to continue the contract. Another factor is how would the termination affect staff? You may consider sending a notice to cure a breach. Some contracts may allow termination on grounds of a remediable breach only after the aggrieved party has given another chance to cure the breach within a specified time. So termination under the contract. I will now look at under the contract and look at those three grounds. Grounds for termination, I've got insolvency, material breaches or default, or termination by convenience or without cause. Most standard forms of contract will have provisions for termination where there is no common law right to terminate. In the absence of a contractual termination right, insolvency does not terminate a contract or excuse either party from performing. The same is true if a party gets into financial difficulty. That is the reason why construction contracts usually contain events of default, which allows one party to terminate the contract if the other has or is likely to become insolvent. However, the two most common provisions are the termination for convenience and the termination due to an event of default. The right to terminate by giving an agreed period of notice without any grounds is sometimes called termination for convenience or without cause. This right is useful for if a customer no longer requires a product or the contract becomes uneconomic to perform. Before considering termination, you need to check your contract provisions and check everything you need to be aware of. What are the circumstances which are required before exercising your right to terminate? What are the notice provisions? Whether a single notice or two notices are required before a termination would be effective? Whether the contract requires you to issue a notice to cure? Whether what the contract says about the consequences of termination? For example, what is to be done with documents, the sites, materials, other documents such as or guarantees such as collateral warranties. If you're satisfied that you have valid grounds to terminate, you will also consider your working relationship with the other party and consider whether it would be more profitable to continue with the contract. These are the same reasons, same grounds or same considerations I mentioned earlier in terms of termination at common law. You may also consider whether the contract provides you with other rights or remedies as an alternative to termination. To illustrate this contractual termination, I shall refer to the provisions in the JCT building contract as an example. Just like other contracts, the termination is of the contractors of employment under the building contract. This does not prevent certain rights and liabilities from continuing. The termination notices are not allowed to be unreasonable or vexatious. In the case of Rainwood Limited and Brown and Sons 2008, vexatious is said to mean terminating the contract with an ulterior motive or for the purposes of oppressing, harassing, or annoying the employer. Unreasonableness is determined by consideration of how a reasonable contractor or employer would have acted in all the circumstances, and the court would normally apply an objective test. Reservation of rights. Termination does not affect the ability of the party to retain their common rights. So most importantly, this means that the party retains a common law right to treat the contract as repudiated and seek damages, unless there is express and clear express exclusion of those common law rights under the contract. So how do we terminate a JCT building contract? If the termination is for default of one of the parties, or if an event suspends the work and neither party is at fault, for example, force majeure, a party needs to send two notices. First, the first notice specifying the default, and the second notice terminating the contractor's employment. This should only be brought if the specified default continues for 14 days from receipt of the first notice, which should be served within 21 days of the end of this 14-day period. If termination is as a result of insolvency, corruption, or a grant under Regulation 7.31b apply, then only one notice needs to be served. In these scenarios, termination takes effect immediately on receipt of the notice. There's no warning period. The first notice, depending on the contract, must be sent out by the architect, contract administrator, or the employer. The second notice, however, must be sent by the employer. Under clause 8.7 and 8.12, respectively, in the JCT contract, there are express provision for what is to be done following termination by the employer or the contractor. For instance, clause 8.7 allows the employer to appoint others to carry out and complete the works, including making good any defects, taking possession of the site, using temporary buildings, tools and equipment, and the site materials. It requires contractor, if so required, to remove any temporary buildings, plant and equipment, and provide any contractor's design documents to the employer, and assign the benefit of any contracts for goods, materials, or the works. A termination will also stop further sums falling due to the contractor until a final account is issued and determined, and the employer will be obliged to pay sums already due. The clause 8.7 also provides for reckoning up of sums due between the employer and the contractor following completion and the making of good defects. Clause 8.12, on the other hand, requires the contractor to remove any temporary building and plants and equipment, including site materials, unless these were bought by the employer. And it also provides for reckoning up between the employer and the contractor. So what are the considerations when terminating the contract, the JC contract? These are the factors that you will need to know to consider when terminating your contract. Make sure the site is secured. Ensure that the works are adequately protected from the removal of scaffolding, temporary structures. Ensure that the termination notice is served correctly and by the right person. Make sure you know who will complete the work post-termination and how much longer it will take and how much it will cost. Where a party has a choice to terminate the contract or affirm it, termination normally requires a clear, unequivocal communication. That is, a party must communicate that it is terminating the contract. A letter threatening to terminate if payment was not made in the next 2 days does not terminate the contract. You should also look at the minimum period of notice required under the contract. The notice should identify clearly the length of the notice or its end date. The notice should also be unequivocal. It must either affirm the whole of the contract or rescind the whole contract. You cannot approbate or reprobate by affirming part of the contract and disaffirming the rest. Some contracts often add requirements for the form or content of a termination notice. It is also important both to choose valid grounds for termination and to state them correctly. Otherwise, the notice may, in effect, repudiate the contract or fail to exercise the chosen termination right. When it comes to selecting who is going to complete the work post-termination and assess how much it will cost, I suggest you get surveyors to assess the site and the state of the work, get an estimate from them as to how long and how expensive it would be to finish or repair the work done by the previous contractors. Once you've taken all this consideration into play, you may then consider whether it would be more cost effective to accept the default of the other party or whether to employ others to complete the works. You should also consider, why is the default occurring? Is it because of the contractor or is there another reason? You should survey and check the reasons behind the default. For example, you ask yourself, has it been because of the failure on the contractor's behalf, or is it due to poor scheduling conditions, or too short a time before completion date? If it was due to the latter, then termination is the appropriate remedy for the situation. That is something you need to consider. Risk. Obviously, as I said at the beginning, termination is not without risk. The biggest risk with termination is doing it incorrectly and making it a repudiatory breach of contract. The works could also cost more to complete. It could take longer if the contract is terminated. You should also consider the effect of termination that termination would have on unpaid subcontractors and suppliers. The risk also is on contractor on the receiving end, who may be struggling with cash flow, and the risk associated with expensive and protracted litigation or other means of dispute resolution. What are the opportunities that may arise from termination? Well, in my view, it gives an employer the opportunity to replace the contractor who has been performing badly or their works is of poor or unsatisfactory quality. It ensures that the work is done to a good standard and be completed without delay. On the other hand, it can also give the contractor the opportunity to leave a project which was difficult or not worth their time. And the effort being put in, and it frees them to pursue other ventures. This is my presentation for the termination of construction contracts. Before I take any questions, we have a survey. If you can, we will send you at the end, which we will invite you to take. We'll also send you a link at a very short feedback survey. We really appreciate it if you could complete, so we can make sure our future webinars are helpful to you. Here's a list of our future webinars. Questions?
Thank you, Suryen. We have had one question that was submitted in advance, which is, can I terminate a contract for a force majeure event if there is no express provision giving that right?
I'll repeat that question. It says, can I terminate a contract for a force majeure event if there is no express provision giving that right? Under English law, there is no specific rule of force majeure. If the contract does not have a force majeure provision, then no particular consequences will necessarily flow from an event which the parties may consider a force majeure. The common law doctrine of frustration may apply if performance has become legally or physically impossible through no fault of the parties, of either parties. If the failure to perform, therefore, is a breach, it will normally give the other party the right to claim damages and possibly also the right to terminate. I hope this answers the question. Is there any other question?
Thank you, Suryen. No, that'll be all the questions for today. So I'll hand over to you to finish the webinar for tonight.
Thank you very much. You have my contact detail on the screen with my email address and phone number if I can be of assistance, or if there's any inquiries about future webinars, do not hesitate to get in touch with me. Thank you.